All right. It looks as though we continue to have folks joining us. I think we had 189 registered today. So we'll see how the day plays out with folks being able to join. But I want to thank you all for your time this afternoon. I'm Tatia Davenport, the CEO of CASBO, and happy to bring you today an important topic of compensation and extended year programs. This topic has been receiving a lot of attention from our partners in labor. And so we want to be sure to serve our members best by bringing expertise and recommendations to make sure that you're prepared on all fronts around this important topic. So that said, I'm so happy to be joined today by two of our partners at CASBO, but also two amazing organizations in the legal environment. Most of you would know these names. From Lozano Smith's Fresno office, we have Janae Castellani. She's senior counsel at Lozano Smith. And also joining us is Seth Eckstein. He's a partner for Fagan, Freeman, and Fulfrost, also known as F3. So thank you both for your time and expertise today. I'm going to just make a couple of logistics announcements and then turn it over to you. But let's start with, we are recording this webinar, and so it will be posted later, probably this afternoon once it processes. So you'll have this as a reference. There are no slides, so no need to ask. There are no slides. We're just going to have a nice panel conversation. But I will encourage you that if you have questions, please put it in the Q&A. The Q&A allows us to capture that question. If for any reason we are not able to answer during this session, we can follow up with our experts and get information back out to everyone for questions that we were not able to get to or were not able to answer. So with that said, questions are going into Q&A. We are recording. And Janae, I'm just going to ask you to sort of set the table on the background for why this has become such a highly scrutinized topic right now, why it's getting so much attention. Give us some background and help us understand where we're coming from on that.
Perfect. Well, thank you. So this discussion and probably the interest in the topic is prompted by a necessary and relevant information request that many districts across the state, county offices as well, have received. And so there is now a focus on extra duty assignments as well as summer school, extra extended school year programs, specifically focus on compensation and benefits provided to classified employees who are performing work in those programs. And so hopefully today we can talk through generally some of those topics that have been raised as a result of that necessary and relevant information request, as well as to discuss those requests in general as well. So that's really hopefully our focus today. And I'll also let Seth add anything else that he would like to.
Oh, good afternoon, everyone, and thank you for having me here. I share, I think, Janae's experience. I'm sure many of you, and I won't ask for hands, but I'm sure many of you have seen some version of an RFI come across your desk. Usually it's from CSEA lately around this issue. You're not alone. Know that we've seen that statewide. So it's very clearly an issue that has our labor partners' attention and therefore has our attention. And we've I think collectively we've advised on a number of clients on this issue. And so happy to be here today and both to kind of share our thoughts and then also kind of weigh in on any particular concerns that folks have.
Thank you. Well, let's just start with some of the bullets that we put into the invitation. Comp and benefits for holiday, supplemental time, and extra hours. What guidance do you have to share in that area?
Right. So as part of the request, that is something that is highlighted in terms of asking for information about whether or not holidays have been compensated, as well as sick leave and vacation time. So that's really the focus in terms of those three factors, whether or not those practices have been implemented through those kind of extra assignment or summer school programs. So we have, I think what I would like to start with is the idea that this is not going to be a one size fits all, right? We have, as well, with labor partners being interested in this topic, there may be different structuring of programs and different ways of, how everyone has been structuring their summer school programs, for example, negotiated different language for those benefits. So we, have statutes, we have case law to help to give guidance, but it's going to really be a fact-specific analysis in terms of how those may apply to individual employees as well as your district programs as a whole. So that's one of the benefits of, seeing we do have statutes to point to, but it's really going to be a collective look at all of those factors when we're really thinking through risk assessment and those types of things as well. So, Seth, do you have any other thoughts on that?
No, and I think the only thing I would set the stage for is I would imagine many folks are familiar with the Juneteenth litigation that happened maybe a couple of years ago. And for those of you who aren't familiar, CSEA filed a class action lawsuit against many school districts throughout the state, demanding that their members get paid for the Juneteenth holiday, that led to a kind of a lengthy litigation. I think it's actually still ongoing. There are a couple of holdouts who are still litigating the issue. And to me, the RFI is a little bit of a signal of what might be coming down the pipeline. I think there may be a pivot here from the Juneteenth litigation to what's next. And I think, maybe it doesn't take much tea leaf reading to say that they're kind of signaling here that there may be some litigation coming up in the future around, do summer school employees, are they entitled to sick leave? Are they entitled to vacation? Are they entitled to holidays? What has been the practice, to date? And like Janae mentioned, there are, we have to be careful not to create kind of a set, a set rules around every situation, because everyone's summer school can be a little bit different. But I think there's some information we can glean from the statutes and what limited case law there is out there to kind of get a sense of if this was litigated, how this is likely to turn out. So.
And you mentioned going back to the labor agreements, and most are those specifically called out in a particular area. If someone's brand new to their role, receiving this letter, what would be some of their first actions in terms of looking at that agreement? What are they looking for?
So, yeah, sure. So I think it depends, of course, it's going to vary by your district. We see when it comes to items such as sick leave, vacation time, and holiday pay, those are typically going to be in your collective bargaining agreement, spelled out. But when we're talking about specific programs like summer school or extra work or, extended school year programs, those may also be governed by separate MOUs or side letters. So it's really going to be a collective effort to see. And interestingly enough, with the focus of the RFI being all the way back to 2020, you could have many different agreements in place. And I think one of the things to consider with looking back that far, with COVID funding available during that period of time, there may have been separate agreements with the extra funding available for that type of extra work. So really looking at practices as a whole. And so I think that really goes back to my point about it being so fact specific for each individual school district.
And based just quickly, and I want to hear from you, Seth, too, based on what you said, though, there may have been programs that funded some of that. It sounds as though your HR and your finance folks are really going to have that conversation and sit down and understand where truly that intersection is between how those were paid in the past.
Those are probably, and it's a collective effort, with in terms of my experience in working through the request, it's going to impact both, probably your human resources department, whoever may be at your bargaining tables, as well as who's responsible for payroll. So multiple departments may need to be involved in the conversation to really understand it, collectively.
Our poor payroll departments, they're so understaffed as it is. I'm just cringing with all the work that is already out there. But yeah, Seth, please comment.
Yeah, no, the thing I would say is, and I agree, you can start with looking at your collective bargaining agreements. If you have language, great, and that may help the parties. I think that's particularly helpful for your locals, right? Your local presidents, your locals who are maybe inquiring on behalf of the larger CSA organization, and they would want to see some sort of, what's spelled out in the collective bargaining agreement or some things negotiated. And what I would say is be prepared that may not satisfy the larger CSA organization. And the reason why is, to the extent that CSCA feels that these are statutory rights as opposed to contractual rights, they're going to hit hard on the fact that individuals can't contract away their the collective bargaining agreement cannot contract away individual rights that are held in the education code. That those are rights that individuals possess, and that a contract can provide additional rights or clarifying those rights, but they can't suddenly say, for example, if your collective bargaining agreement says, individuals will not accrue whatever, sick leave, vacation, or so on, but if there's a point in the education code where that right is afforded them, the union cannot negotiate that away. So that's the sort of caveat I want to point out.
An important point. Ed code is going to trump any of the other, if you will, local type of agreements. Correct. That is the prevailing law.
Correct.
Okay, thank you for that clarification. We've already got questions coming in, so I'm just going to jump to those to make sure we get those answered. The first is, do we need to deduct CSEA dues during summer school hours worked as well?
Yeah, that's a great question, and I think frankly, I think that is a deeper dive we need to look at into their current status. And this goes back to Janae's question about, one size may not fit all. You may have something spelled out in your collective bargaining agreement about how dues are collected or when they're collected that may guide this. But I mean, I think the question is, if they are in some sort of paid status that would normally trigger their entitlement to dues, the answer is possibly, but I think it very much will depend on your unique circumstances, that how you've negotiated when dues are collected.
Right. And I would look at that organizational rights type area of your contract to see, because many times that's going to be within that language in terms of how many over 10 months or over 10 payments or 12 payments. So that's going to be spelled out in that type of language in terms of deductions.
All right, here's this one looks pretty deep here. What should we consider for catching up on prior missed vacation payout and sick leave accrual for employees who left or resigned employees for the summer assignments? How do we fix CalPERS? That's a big question.
So there's a lot in there. I guess the one point with CalPERS, and so that was also one of the things that was asked about in the request. So it's understanding whether that extra time in summer school for folks was reported or not. And so one of the things in terms of any correction or re-reporting when it comes to PERS, the one thing to caution is understanding that districts don't hold the jurisdiction to make decisions whether or not something is reportable or needs to be fixed or re-reported. CalPERS is the entity that has that jurisdiction, and so to be very cautious in terms of agreeing to any language if you are, cleaning up or whatever it may be, to state that the district will report something or something is reportable, right? So you may, if there is concern in that area, may want to reach out to PERS and to seek their guidance before just unilaterally agreeing to anything or making some adjustments. So that's what I'll say about the PERS element. And Seth, go ahead.
Yeah, no, I think that's right. And I think the important thing to recognize is that you have your earnings that go into a defined benefit plan and earnings that go into a defined benefit supplemental plan, right? And so traditionally your earnings from as a 10-month employee, that goes into your defined benefit plan, and anything above that goes into your could go into a supplemental plan. And I would not make the assumption that these earnings are necessarily additional defined benefit. They may be, and I know I'm talking about STIRS for those who are talking about, obviously a lot of this is in PERS, but the idea that what PERS ultimately decides as, something that gets counted towards that individual's a pension, it can vary, and so it goes back to letting them make that decision, not necessarily having the making the assumption that it is. So
yeah, and just to kind of piggyback off of that, the idea in the statutes governing CalPERS and pensionable compensation, classified employees have a full-time definition when it comes to pay. So it's based on a 40-hour work week. So that's why with most of you, if you're familiar with, payroll when it comes to PERS employees, there's a lot of conversation about 260 days, 40-hour work weeks, and that's because it's built into the definition of what's full-time for pay purposes. So there is some guidance, older guidance regarding summer work for, your traditional instructional calendar folks. So maybe working 180 days. But the reason why there's some caution with relying on PERS guidance as opposed to making those determinations at the district's level is that depending on how you've structured your pay for those programs may differ in terms of whether or not something may count. It may also be on an employee by employee basis, depending on how much time they work. So that's why it's really important to rely on PERS. And so it's not going to be a one size fits all on that particular issue, because we have seen kind of some different guidance being received from PERS on that particular issue, depending on how the pay was structured.
Thank you for that additional clarification. For anyone just joining us, we're going to ask that you put your questions in Q&A. They are recorded there and we can follow up on those. So instead of chat, please put them in QA. I see a couple very, very brief, but I think the one that's in chat was also just answered. Will PERS speak to this sort of as a statewide issue? It really sounds like it's a district by district, person by person issue. So at this point, we can certainly reach out to PERS, but at this point, I would suggest that they might not. But we can circle back with them to see if they have any guidance, statewide. So again, let me just kind of continue. We've got some questions building up here in Q&A. Is the Juneteenth holiday a paid holiday by Ed Code? Our county has districts who added this as a paid holiday and some that did not, as they could not find it in Ed Code that the holiday must be a paid holiday.
Seth, if you want to take a stab at it first, you can.
Yeah,
it's complicated.
It is complicated, and I could probably have a whole seminar just on this. But the basic idea is that when Juneteenth came out, was first, so just a background, Juneteenth was first recognized by President Biden following congressional action. And there became this question about whether or not that recognition by President Biden was sufficient under the education code to qualify for that holiday recognition that basically says, and I don't have the exact language in front of me, but it's something to the effect of, when there's a presidential action that occurs. And that is when and some districts interpreted it as, no, it wasn't enough. Some districts took it as, say, yes, it was. And that's around the time that the CSEA litigation commenced. Subsequent to that, Gavin Newsom and the legislators have effectively adopted legislation that has clarified this and really has kind of, I think, put, in my view, put the issue to rest in terms of, in their view, saying that yes, the Juneteenth is now a holiday and should be recognized and under the education code as a holiday under that subsection. And that's, and I think that's, as far as I'm aware, that's kind of, at least in terms of the people's interpretation of whether or not it should be counted, has kind of put that issue to rest.
Right. And so if someone's looking in the statute for the term Juneteenth, it's not going to necessarily be in there. It's going to fall under that appointment language in the alternative. So some districts have chosen just to add Juneteenth to the list of holidays to really spell it out, where others are more focused on, the direct terminology in the statute. So that's kind of the nuance there.
That one took a minute. Thank you for that clarification. All right. I hear vacation and sick accrual for summer work also applies for additional assignments throughout the school year. I've heard different interpretations on this. Is there any additional assignment?
Dave, you want to take that? I can.
Yeah, I think that, we have this statute to really drive that question in terms of 45102. Looking at that, I think that arguably, because of how the statute is written, there may be some differentiation in terms of extra work versus summer. So I don't think it's again going to more, in my opinion, how the district wishes to handle that issue, how you've negotiated extra work. I think summer school is a bit more clear in the statute in terms of the idea of paying compensation and benefits a certain way. But I don't know, Seth, if you have certain feelings about that differentiation.
Yeah. I mean, I think if we're talking about during the regular school year, my inclination is to say no, that they're not, because if you look at, so the two statutes that I'm thinking about, 45191, that's the one for sick leave, and then there's the other one is 45197, and that's the one for vacation. Both of those talk about if you, in the regular school year, you are essentially accruing each month a amount of leave, provided you sort of meet that threshold. And the way I read that to say is, okay, if you've gotten a day for that working that month, whether you were however much time, so long as it's the limited amount of time that's stated in the education code, you get that. And you don't. I have not seen arguments that they necessarily are entitled to more during the school year. But, and this goes to Janae's point about during the extended year, and that's the sort of the crux of our conversation. And frankly, what CSEA is kind of getting at is that 45102 says that in that interim between the end of the school year and the beginning of the next school year, right? If there are additional services provided, then they're supposed to get the same salary and benefits that that folks would get during the regular school year, right? And I think that the question then is, and this is more legalese, this is kind of what the lawyers kind of argue about, is whether that concept of compensation and benefits specifically refers not just to say your medical benefits, but any and other benefits that you are entitled to under the education code, such as leave accrual or vacation and so on. And so the argument where I think CSEA is going is they interpret that term benefit broadly to be anything, any non-compensatory thing that a person gets. If they get it during the regular school year, they should be getting it during the extended school year if they're working that.
Mm-hmm. Exactly. Yeah, I agree.
All right, thank you, Seth. We're going to take a couple more, and then I want to make sure that you all are able to move on so we can talk about how calculate non-overtime hours and retirement considerations and other things that we had promised on our webinar. So one of the questions, is there a reference to the CSAA argument of giving employees a sick leave allowance for extra hours if our bargaining contracts do not address that?
Yeah, and I think that that goes to the argument that's likely going to be made is going to be a focus on that 45102 language, and then comparing that to the 45191, which addresses sick leave, for example. So it's looking at those statutes together with your contract language to determine how that's going to be all interpreted together. And I think that, it also goes back to the idea of a risk assessment for some folks in terms of, we can assume CSEA is going to make an argument that's likely going to be more beneficial to your employees. So, how comfortable are you in terms of strategy? And so that will all be part of that discussion for your individual district. Go ahead, Seth.
Yeah, and the only thing I'll add to that is there's also the practical consideration of just how do you calculate what should be someone's, sick leave or vacation accrual when you have kind of a fluid time period like that summer, right? Because you're really, it's hourly. There may be different days you don't necessarily fully know, maybe you do, but and this goes back to the idea of, there may be a benefit, and this is where I think the bargaining with the locals can come in handy, is if you bargain something that is just easy for everyone to administer, you're probably it may be it may be beneficial to folks just to kind of think about, okay, here's the floor of what the education code allows or requires, right? And it may be that it is some, prorated amount or whatever, but the work on the back end for everyone's staff, right, of tracking how much someone actually worked in a given month may be hard, and it's sort of more, what's that saying, the juice isn't worth the squeeze, to be really focusing on just down to the minutes of how long someone worked. And it may be beneficial to people to kind of negotiate something that's just some sort of flat amount so that you're not dealing with that.
Well, and that's a great point, and especially when we're even looking at the differences between what's in the statute for sick leave versus vacation, right? With sick leave focusing on a day basis, right? And how do you do that practically in terms of proration if the additional work or summer work is not consistent, right? If the schedule is not consistent, you're having an employee work a few hours here, a few hours there, how do you track that and how do you do a proration? So I think that's a great point in terms of the practical side.
Thank you. And so in the CSA letter, there's a lot of information that's been requested. I think one of the conversations we wanted to have was around how we're to calculate the non-overtime hours. Can you spend a moment on that?
Yeah, so I think, we've seen districts doing different things in terms of tracking. So really in terms of how to track that time, in gathering the information in response to the information request, it may help shine light on what your district has done in terms of how you're tracking. So, it may be timesheet work, it may be a more set schedule, it really just depends. And so I think that's part of the work on, potentially the district side while you're collecting the information, is to truly shed light on what your practices are for each of these different types of programs and the additional work, because it may be different, right? Your district may have a very set way of tracking hours for summer, but the extra time performed during the work year may be a little bit different. So I think that that's one of the things that would be a recommendation in terms of, as you're gathering the information, that you're also really doing a deep dive analysis in terms of what have you all been doing? What are your practices?
And especially highlighting any changes in those practices during the requested time period.
Absolutely.
I think would be very critical. Seth, anything to add to that?
No, I think that's right. I agree.
All right, moving to retirement consideration, regarding, summer school programs. What can you share on that?
Yeah, well, I think Janae had mentioned this earlier, that I mean, preliminarily, the idea, and I think the takeaway I've been getting as well from PERS is that, these hours go beyond their regular, 40 hours or however many hours during the school year that they are per week, that they are earning, and that it isn't going to be something that PERS is going to ultimately, count towards their retirement. But that is ultimately something that the PERS decides, and that's something that, we the districts will have to let them kind of make the final decision on, what they want to do with that, with those additional earnings. I actually think there's some case law kind of to that point that actually confirms that that it isn't, but it's it a lot of the case law out there is kind of close to the issue, but not quite there. And, I think one of the things I want to flag for everyone, is that I think two things. One, the case law out there, like I said, is not particularly robust or, as you might want or hope on this issue. But two, it is, to the extent that there is stuff out there, I think there's a general favoring towards the employee on a lot of these issues. And I say that more as a caution for folks to understand that we are, to the extent that we are, individuals are looking to litigate it, be aware that, I think where there is, if there is any place for ambiguity, there does tend to be a bit of a leaning, employee side leaning in terms of how these cases are turning out.
Yeah, and just a couple of other points in terms of CalPERS specifically. So just a few kind of high level concepts. There is a definition of overtime for purposes of CalPERS reporting that does differ a bit from the definition when we think of, your regular FLSA definition of overtime. So just making sure that if that's, a question, whether or not the time is reportable or it would fall under the definition of overtime for purposes of PERS, that you've taken a look at that, and also thought that through. I think, unfortunately, a lot of as I had mentioned, a lot of the CalPERS guidance regarding summer work is a bit outdated. So it's not entirely clear where PERS would take in terms of a position for both classic and new members as of, the time period we're talking about with the request for information. So that's also something that may just be best to reach out and confirm based on your actual practices, how it should be reported. And then lastly, one of the things that we've seen a lot with CalPERS in terms of audits of late is really a focus on salary schedules and whether or not they're structured properly. So if, for example, you're a district that may pay employees, classified employees specifically, differently for summer work or for additional work outside of what's included on a salary schedule, that may also impact reportability. So there's a lot of factors involved. And again, that's why it's so important to really have PERS involved in the discussion before any re-reporting or anything like that may occur.
And so going back to the letter, as the requests have come in, how should districts really be approaching like sort of the totality of the responses? Get your ducks in order, understand your own processes, highlight any changes, talk to PERS. What else do we need to know in regards to this request?
Yeah, great question. So I think one of the things that has come up a lot is a question of what does this request fall under in terms of how do we process it? I think there was some potential confusion in terms of whether it should be treated like a CPRA request versus a request for information under the ERA. And so when we're talking about necessary and relevant requests under the ERA, there's a broader kind of right to information for an exclusive representative to essentially any information that's necessary and relevant to them, meeting their requirements as that exclusive representative. So it's fairly broad right to information, more than what a general public may receive under a CPRA. So with that in mind, even though it's not unlimited, I think that there's really a lot of risk in not responding at all. So some type of response, and I think if there even is some questions about how do we process this, how do we meet, the timeframes that have been placed in the letter, how do we, with the scale of information, how really do we tackle this? That may be a place to communicate with your local CSEA to really come to an agreement in terms of how can we make this disclosure more manageable. And so we've seen varying degrees of what local reps may agree to, but we've seen, some folks be successful with sample sizes as opposed to anything and everything that may fall under the request. So it may become more manageable in those situations, but there is varying degrees of strategy in terms of how to respond, but just kind of those key points in terms of how do we tackle it, in the beginning. Go ahead, Seth.
Yeah, no, I think the thing I think everyone should know from the start, like Janae says, this is an RFI. Really, this is under the EERA. They're entitled to reasonable and necessary information in the representation of their members, and this really does fall under that. I think that ambit. So I think anyone who is looking to not respond at all, I think is running the risk of an unfair practice charge.
Absolutely.
Around the production of these documents. There's nothing under the EERA that says you have to produce it by a certain date. So if your letter says, what they sometimes do, say something like, I expect this information by such and such date, that you don't have to meet the dates that they articulate. You're supposed to get back within sort of a reasonable period of time, which depends on the context, the nature of the allegation or the questions that they're asking for. And the burden is to treat it on the employer, the district is to treat it like, a serious business request. And strategically, what I would say is, and like Janae was saying all along, is if you feel like you need more time, document that, reach out to your local, say, look, I got this. This is a lot. I got a lot going on. We're going to get to it. And, I just want to acknowledge that I haven't forgotten about it. And then if as you're working through it, if you're finding yourself needing even more time, give what you have, right? Give them something that you can say, okay, here's what I got so far. I need additional time for whatever. And what that does is it shows a good faith from the district in responding that undermines their ability to then go to PERB and file an unfair practice charge, because you are showing that you are, diligently going through it. And I think under those circumstances, I think they are harder pressed to be able to prevail on any sort of claim that you haven't, complied with the RFI requirement. And then in terms of strategically, I think, like Janae also mentioned, I think you can have conversations about if you feel like there are aspects of it that are too broad or over demanding, or, you can ask them, your local, say, look, can I provide you this? Can I, and that, does this get you what you want? And that may, if they agree, then you're helping yourself by narrowing the scope of the response. They may say no, because I think my sense of this is that this is very much driven by the larger CSA organization. So they may just kind of be towing the line and just following it up the chain of command to see what they want. But I think if you have a good relationship, particularly if you have a good relationship with your local, see what you can do to just kind of narrow it to as much as you can.
Yeah, and that's a great point. I don't think that there's anything that's going to prevent a rolling production. Obviously, just recognizing the reasonableness standard, if that's something you can at least agree to, document anything you agree to in terms of, what that production may look like. But again, showing that good faith effort, that rolling production can be one way to assist with that process as well.
And I do appreciate you pointing out that some of the local CSA leaders have been completely unaware, or at least indicated they're unaware of the letter in the first place. So there's a disconnect there, and really leverage that local relationship to open up communication to help both sides kind of meet the goals, if you will. Anything else to add on just the letter itself? And we've talked about the timelines not being directed by CSEA, excuse me. The importance of initially collaborating internally, HR, your finance, payroll folks, really get your arms around the plan, communicating with your local representative, try to get a rolling production schedule potentially in place, and document that schedule. And again, just clarification of the aspects of the requests that are broad or ambiguous to you. It sounds like a good start. Is there anything else to add to that list?
No, I think that's fairly consistent. I think we have started seeing, at least at the local level, some agreements popping up to address some of these issues. And so, recommendation in terms of making sure those things, in terms of knowing what your practices are, change in practices, really having your arms around it before being able to have those discussions may just help in the long run, have you be most prepared when you're needing or potentially presented with something. And I think that recognizing this may be one of those things where, calling your neighbor district may not give you all the answers because your district may be a little bit different. Your local rep may be handling things a little bit differently. So just with caution, obviously, it's good to know what's happening around you, but also recognizing there may be some nuances or variations. So being prepared for that as well.
Thank you. I'm going to get us back to just a couple of the questions that we have here. Here's one. I do not have our CSA letter in front of me, but beyond sick and vacation accruals, IIRC, they were also asking about holiday pay. This 4th of July is a useful example. It falls on a Thursday, where our 260-day classified employees receive that as a paid holiday, but our class folks who are on shorter term assignments but have opted to work summer hours, aides and the like, traditionally aren't paid that holiday. My preliminary read is that we should strongly consider paying those summer holidays. Is that reasonable?
That's my read too, candidly. I mean, I think that, I don't know if Janae feels otherwise, but I read the education code saying if you're in paid status the day before and the day after a holiday, that you're entitled to that holiday. And I think for the most part, people have, I think probably avoided that because July 4th is, so few people are working in July 4th. But I think this really came up during the Juneteenth discussion because you actually had a lot of people who were right at that cusp, depending on where their school year fell. And I think it's kind of highlighted that, if you, again, the Ed code does say if like you're in paid status the day before and day after that, it is something that you should be entitled to.
Yes, I think that's, not only a statute, but one of the cases that is cited also kind of focuses on, in that letter, focuses on that. I think it's the Santee case, I believe, focuses on that. But I think that if you have a practice of, how you handle July 4th, it may be worth a further discussion in terms of how you want to handle that moving forward and if it would be adjusting any practices. And recognizing, I think there may be some conversations between certificated staff and classified staff that there just need to, be thoughtful distinctions potentially in terms of changing those practices. One thing to caution though, I think because it seems, if not very clearly, stemming from the Juneteenth litigation, if you're entering into any agreement about the Juneteenth holiday as it relates to holiday pay for these situations, just recognizing that litigation is still pending and that you may have entered into some agreement while it was pending, or it may be part of an agreement once everything with the class action settles out. So just being thoughtful about that still lingering out there and just not getting yourselves potentially into any circumstances where things may be at odds with one another or anything like that.
Is there an expected date of the settlement of that? Okay.
I feel like there was a court date this month, but I'm not positive and when we can expect it to be all wrapped up.
Thank you. All right, continue with the questions. Digging deeper into a prior question. This is one of those real life examples. We have a part-time CSEA member who can only earn partial PERS credit. So if a 2-hour food service worker picks up another 2-hour job as noon duty aide, then this worker would need vacation and sick leave accrual for both positions, even if this is a temporary substitute work versus if it's permanent?
Well, I mean, Janae, feel free to, I'm happy to jump in, but yeah.
Go for it.
So, well, first of all, keep in mind that even for substitutes, there's new law out there, relatively new law that talks about how there are, they're entitled to a minimum amount of sick leave. And so, in terms of then whether they are then eligible if they're, working these combined amount of time for a certain amount of sick leave or vacation leave, the answer is possibly. I mean, you have to look at specifically look at education, the two education codes I mentioned earlier here, 45197 and 45191, to see, because there's a certain minimum amount that triggers their accrual rights. So they might be entitled to be sent to something, depending on if it reaches that threshold.
And I think from the RFI too, we're kind of reading the tea leaves in terms of what arguments would be made. And so if we're looking at your part-time staff that have regular assignments and you're adding on to that, right, it looks like they're trying to make the argument that any existing classified employee picking up additional work, whether through summer school or extra time, even if it's not, on a kind of long-term basis, they wouldn't fall into the category of substitute or short-term as defined in the statute. So I think it looks like, with the citation to the testing case, and really that was specific to extended illness leave and subdeduct pay, but that's likely where their argument would fall, is that these folks are part of the classified service and therefore not substitute or short-term, even if doing short-term work in terms of a summer school program, for example. So I think that's a much larger discussion, definitely nuanced and in the weeds. And so if that's something that is of a concern to your district, I think consulting with your legal counsel for that purpose, because it does get a bit complicated.
All right, we continue to take questions in Q&A, please. Next, our collective bargaining agreement states an employee hired for summer school do not receive health and welfare benefits unless they are already entitled to such benefits. However, they must receive compensation equivalent to the regular academic year for the duration of the assignment. Does Ed Code 45102 supersede our CBA in this regard, particularly concerning health and welfare benefits and fair compensation for summer school assignments? I believe we heard, go ahead.
Yeah, well, this goes back to what we were just talking about earlier, is that a collective bargaining agreement can provide rights that either are not in the education code or greater rights than are, afforded under the education code. But the education code remains the floor. And the only way you could have an individual sort of waive those rights is if they individually waive the rights. It couldn't be that the union on their behalf, collectively waive those rights. And then in this case, to the extent that the education code, and this, this is a debate, but to the extent the education code provides for an allowance for accrual of sick leave, vacation, or other benefits during the summer, that would not be something that an MOU or or other negotiated document can supersede and sort of erase or take away.
Yeah, and I think also to Seth's point earlier, in terms of what the statute says, it says, obviously paraphrasing, but compensation and benefits without a very clear definition of what it means by benefits when we're talking about summer programs. So I think that, and unfortunately, the statute is not the best in terms of how it was written to clarify that, nor do we have any case law within the last 30 years on that particular statute. So I think that there is some gray area in terms of what that term may mean. So it'll be interesting to see, because of course that is not something in the request. They did not ask about health benefits. And so who knows if that's something that may be factored into the conversation. So I think that's to be seen at this point of how what arguments would be made regarding that particular benefit.
I love all these questions coming in. If a summer assignment is added to an employee that would add months to the contract, which would then make them ineligible for programs that are offered to non-12-month employees, such as classified school employee summer assistant program?
Yeah, so that, interestingly enough, has been a question that's been raised. I would prompt you to look at the summer assistance program language in the statute in terms of eligibility. And interestingly enough, you can read that language to assume that the legislature was prepared for less than 12-month folks to take on summer work. So there may or may not be an eligibility issue with them taking on summer work. So I think that just requires a little bit more analysis on that particular issue. I don't think it's a very clear yes or no of the forefront. But Seth, of course, if you disagree or have seen anything different.
Yeah, no, I think that was my take as well.
All right. Was the question of sick and vacation accrual necessary for an extra earning assignment for a part-time employee? For example, employee works 3 hours a day and is working an additional 3 hours a day as extra earnings. Would they accrue additional time for the extra time worked?
Well, so this goes back to, I think, the point we talked about is regular school year versus extended summer school, right? So if it is during the regular school year, the education code says you accrue 1 per month, or however it is prorated depending on how much time, and that's just the end of it. It doesn't talk about entitling anyone to additional leave or accruals in any way. So my stance is that during the regular school year, the answer is no. I think that it is the harder, or the sort of the area where, and I think that CSEA is getting at, is this summer piece, right? Between between the end of the school year and the start of the next one, what does the ed code, or what is the contracts, or what is, what are people entitled to? And that's the piece where, I think the answer is possibly. I mean, I think it kind of depends on how you interpret that, not 45102, but also the other statutes. I think there's another argument that may be made, is that independent of 45102, are the other two statutes on their face clear as to what when vacation and sick leave are owed, such that if essentially if it says you're in paid status, and what does that mean? Is there some sort of nuance to that term, in paid status, and does that could be another basis by which they say that, yeah, that there's an accrual owed.
All right, thank you. We're going to race through. We've got 5 minutes here. I want to get to these questions. Paid status the day before or after. Does that mean that the day before or after is an actual work day, correct?
So, right. So that they're working. So for example, if you have, if you if July 4th falls on a Wednesday, then you're working the Tuesday and the Thursday. Or if you're, if it falls on a Friday, you're working on the Thursday and then the Monday. Basically, that's the sort of, that's how the education frames it, as that triggers the duty to pay for that holiday.
Should we apply the holiday pay all year long for employees that don't normally work the holidays? Does this apply to subclassified employees?
So with the 453, now I can't remember, 45203, there we go, 203, in terms of keeping in mind, there is that very clear, statute in terms of defining whether or not someone falls in the classified service. So that statute is governing classified service. So if they're a true substitute, that wouldn't apply necessarily, right, to them. It's again getting to whether or not you've properly classified them. And so I think that that's one thing to consider in terms of that question.
Thank you. Excuse me, noon duty aides are not covered under our contract. Would that still count? Would that work still count?
Janae, do you want to tackle that, or have to talk?
Go ahead.
So as you know, there's that new legislation that talks about noon duty aides as now being part of the classified service, and so that I think the short answer is it could. If they're not part of your collective bargaining agreement, it may raise the conversation with your local, or you may just want to let them raise it for you at some point down the road. I mean, the short answer is they could be, but I think that's something that, like Janae started from the outset, all of this depends on what you have negotiated and what your labor partners are pushing. And so I think that should be a driving factor.
All right, down to two more here. We normally pay staff by time card for summer school and had paid them for time worked only. Would you recommend we do a summer school contract, which would include holiday and vacation pay, just like we do with a normal 180-day contract?
I think that's an option. I think that's one way to address those issues very cleanly in a way that can define that. So that's definitely one avenue to take.
Yeah. I mean, I think, I think the combination, I think the two factors you're thinking, I think people are helpful to keep in mind is one, obviously what the law says, or what do people feel comfortable with in terms of the risk and assessment of what the law ultimately would say in litigation, and two, what's the most easiest to administer, right? There may be and different ways of doing this, but you're talking about a span of maybe a month and a half. A lot of your staff are probably focused either on vacation or focusing on onboarding for the next year. Do you necessarily want to take them away to be doing true ups of, people's work hours for the purpose of, leave calculations? And, is there a benefit to some sort of flat amount? I don't know. Everyone's different. It may be worth your time not to deal with it, to do it differently. But, it's just, I think that's up to, I think, your programmatic needs, to decide.
Two real quick ones right under the gun here. One is, where can we find that language about the noon duty supervisors being part of the union? Where do they find that information?
Oh, so it wouldn't necessarily be a part of the union, because that's something that would be negotiated with the union. But there's, and I'll have to find it, but there was a recent law that changed, because it used to be that they were not part of the classified service. So I can dig that up and I can find that.
We'll circle back. That's why we have a Q&A. Thank you, Gina. All right, Patricia's question, paid status could also be someone who is out sick or on a vacation either of those days, yes? Paid status could, is that correct?
Yes.
Yeah.
Okay.
It's their work day.
All right, we're going to take one more here and that's it. We're going to close it down. We have a gap between the end of the school year and summer school. Select classified employees work extra hours during that time. Are we required to entitle vacation or sick for those extra hours?
my recollection of 45102, it's not specific to summer programs. It really covers that gap time once your instructional calendar ends and the next one begins. So I think that may be something to just be thoughtful about, even though there's the request is focused on summer programs, it may not be limited as such.
Yeah, the only thing I would add is that sometimes or often you have your instructional calendar starts at, let's say, August 15th, but you have return to work at like August 10th.
Right.
So if their true start date for the employment is August 10th, then that's not outside their sort of the calendar year that would entitle them to some sort of additional pay. Whatever you've negotiated with the union from that August 10th on, that's what they would get paid. It's something that is outside what you have calendared for their regular work work time.
Regular assignment. Great point. Yeah.
Wow, what a lively discussion. Thank you both for the expertise and perspective that you've brought to the table. I think we leave with some really foundational and practical approaches to responding to these letters and to making sure that we're prepared to give the best response. And Seth and Janae, I thank you and your firms for supporting our webinar today. For anyone else that's on the line, we did record the session. We will be reposting this and circling back with a couple of follow-up items that we didn't get to today because of the very popular topic. But again, thank you for your expertise and being a part of this conversation today. We appreciate it.
Thank you.
Thank you.